compelling circumstances, praying for getting the matter be hard expeditiously. Because my land already been taken away by the Panchayat authority. They have constructed metal road on the road. I could not prevent it. Neither the video, neither the STO, neither the DM, none taken any step. Despite repeated representation, my lord. Let it be, my lord.
File it, sir. I cannot take it so urgently. Many matters are waiting for disposal.
I am aware of that, my lord.
No, sir.
Later direction will be passed after within 7 days or 12 days.
No, sir. Sorry. You file it in an appropriate case, thereafter I shall consider. Yes.
After that, I shall mention, my lord.
You may mention, but I cannot assure you that it will be taken up the next month. You file it first.
But I have already mentioned on Monday, but it has not been listed.
Sorry?
Not been listed. But I have already mentioned on Monday. That matter has not been listed till.
Under the heading?
Under the heading.
Hearing matter?
Motion.
Why not? Give this slip.
I mean, number.
Huh?
It was directed by the.
No, at least. Sir, as a matter of fact, I take a motion and fix motion matters from the month list. It is in the month list.
No, it is not a monthly list. I have mentioned on Monday.
Give it. It will appear in the month list. Thereafter, I shall consider.
My lord, may I mention, my lord, previously I was mentioned, your lordship was pleased to direct the matter to appear in the list, my lord. File lying in court, my lord, on 13th of this month, my lord. There is some urgency, my lord. Your lordship was directed, my lord.
It was in the month list?
No, my lord. File lying in court, my lord, on 13th, my lord.
Give it. It will appear in the month list. Thereafter, I shall consider.
My lord, there is some urgency, my lord. That is why, my lord, I was mentioned.
Yes, sir.
May be permitted to mention, my lord. Last 10th June, I have mentioned before your lordship, my lord, and your lordship was pleased to give the slip, but still now the matter is not.
Naturally, it will not appear because I have a plan as to how I work. So naturally, it will not appear right now. You give the slip, it will appear in the month list of next month.
Lordship, mentioning a contempt application prior to vacation mentioning was allowed. Lordship, the draft is ready with the department. Lordship, directed for release by the Registrar General. It is not being released. The file is in court. Lordship, I am mentioning once again, Lordship. Lordship, a direction upon the Registrar General to release money upon dismissal of the writ petition to me, the private respondent. Lordship, the Registrar General did not release, Lordship. I prepared the contempt application. Thereafter, draft has been prepared, but Lordship, it has not been handed over, Lordship. Prior to vacation, Lordship, matter was mentioned.
Bank draft is ready?
Bank draft is ready.
Then why they will not release?
Lordship, not released because, Lordship, the initial writ petition in the address, Lordship, my address has been described where I was staying at that point of time in 2012. In 2025, Lordship, contempt application affirmed by Aadhaar card or whatever document was given by the petitioner. Lordship is not being released.
Maybe I'm seeking leave urgent to move.
Do not.
17th, the notice was issued for eviction. Communicated on 19th. 19th issued, the 26th will be the date fixed for eviction.
Which authority passed the order?
Appellate authority 10-4.
10-4 has been disposed of?
Yes. Order passed second, communicated 17th from their memo. And another 19th, directive for 26th vacation.
Leave দিয়ে দাও. Let it be appear in the on.
Tuesday, Monday, as your lordship pleases, well.
25th June করুন under the heading fixed motion. Please দিয়ে দিন না.
25th. Grateful to your lordship.
This is a panchayat matter. That's why it has been mentioned for. This is a panchayat matter.
Oh. It is released.
Yes.
It is submitted at the bar.
No, I am for the respondent 11.
I am for the state respondent.
My lord,
Pleadings are complete or pleadings have not been called for?
my lord,
It's followed with the form of report, the accepted is followed already called for and is complete.
Very.
my lord, we have affirmed yesterday an application. We are for the respondent number 11, my lord, for deletion of name of this secretary railways. So, my lord, it will be filed today in due course. So, my lord, I am praying for time if it can be
What was
accommodated.
your predicament in filing the application on earlier date?
My lord, it was not.
13/6.
It was not our knowledge, my lord. As and when we came to learn, we have just filed it, my lord. It will be filed today in due course. It is affirmed.
So why have not filed in the meantime?
My lord, I shall be filing this today, my lord. Today.
Madam, I understand your submission. Try to understand what I am asking.
My lord,
What was your predicament in filing this on an earlier occasion?
it was
So that
not,
it can be taken up today.
it was not my knowledge, my lord. I just come to learn very recently and I have done it, my lord.
What's your good name?
Rini Bhattacharya.
So you appeared on the last occasion.
Yes, my lord.
Then how to
This-
say that it was not with your knowledge?
No, my lord. My lord, kindly accommodate short date, lordship.
দেখি কি আছে দেখি পিটিশনটা একবার মামলা করার হিয়ারিং এলেই সময় যাওয়া শুরু হয়ে যায়
কেন ওর নাম ডিলিট করতে চাচ্ছে কেন?
ওদের কি নোটিফিকেশন এসছে যে ওই রেলওয়েজ এর সেক্রেটারি ও চেয়ারম্যানকে পার্টি করা যাবে যা তখন আসতে হবে সেজন্য ওদের ক্যানটা করে আসছে তো সেই ক্যানটা
notification originally your name was not there. Leave was on behalf of কি দেখি সেখানে when it was added 30th August 2023 you have been added. All along you are appearing. No, I cannot grant you time. Sorry. Give me a second.
তাহলে এটা শর্ট ডেট আছে
Yes, place your case.
May I find my exception? The last report that has been submitted by them.
Respondent 11.
My lord, here, my lord, this pertains to, my lord, the acquisition process by my learned friend's client DFCCIF. My lord, dedicated freight corridor of India. What happened here, my lord, after this acquisition process was done, where my lord took notice, and accordingly, my lord, all the land between all the land users, as also, my lord, the authority, my lord, there have been, my lord, a negotiation occurred. The negotiation, my lord, said that apart from the market value of the land, the solatium and the other part, my lord, there will be an offer for employment that would be given, my lord, to the landowners. It is, my lord,
Who has given this assurance?
the authorities of the DFCCIL.
That is the acquiring body. Acquiring body or requiring body?
My lord, it is the recording body. The acquiring body was, my lord, the railways coupled with the district magistrate who has been, my lord, given with the
No, who is the requiring body? Respondent number 11.
Yes. So, my lord, now what happens, my lord, apart from
So
that,
respondent number 11
yes.
assured you that apart from the compensation, solar CM, you will be provided with a job.
Now, my lord, that document, my lord, which I have
Take
annexed,
your seat.
which I have annexed in my writ petition, my lord, that they might be, my lord, taking this point that my lord, effect of that document, my lord, may not be, my lord, that much, because that is not signed by all the authorities of them. It is a piece of paper that have been signed by all of the land losers, as also one of the incumbent under the authority. So, my lord, I will also not be my lord, depending on that. So, my lord, the Act of 2013, my lord, in this second schedule, my lord, specifically, I do have the Act, my lord.
এই আমাকে বার করে দাও।
The
Act 30 of
right-
2013.
Yes, the right to fair compensation and transparency in land acquisition, rehabilitation, and resettlement.
ওই যে 2013 এর যে ল্যান্ড অ্যাকুইজিশন একটা আছে ওইটা পারবো। দোকানে আসা লাগবে, কালকে পাওয়া যাচ্ছিল না, আজকেও দোকানে বই চলে এলো।
My lord, provides for,
It is Act 30 of 2013.
yes, ma'am, of 2013, yes,
It is Act 30 of 2013.
30 of,
30.
yes, ma'am, yes.
You are referring which provision?
My lord, the parent provision your lordship will find, which is sections 30.
30.
My lord, subsection 2 will be very specific.
Yes.
May I place, my lord? The collector, having determined the total compensation paid, shall to arrive with the final award impose a solatium to the amount equivalent to 100%. Explanation: for the removal of doubts, it is hereby declared that the solatium amount shall be in addition to the compensation payable to any person whose land has been acquired. Subsection 2, my lord.
So one says compensation plus solatium. What is the quantum of solatium? That has been 100%.
Fine.
Am I correct?
Yes, yes, absolutely. So, on subsection 2, my lord, says the collector shall issue individual awards detailing the particulars of compensation payable and the details of payment of compensation as specified in the first schedule. But here, under this particular provision, my lord, the schedule of the act that has been, my lord, given. So, my lord, I will be, my lord, relying upon, my lord, the schedule of this act.
First schedule.
Yes, first and second schedule as well. So, my first schedule, my lord, is with respect to the solatium, because I'll have to. I was about to argue, my lord, about the 100% solatium in addition to the compensation that you has already fallen from your lordship. I will not make my further submission on that effect.
Very good.
With respect to subsection 31, my lord, sees 31. That was my submission that this solatium has to be 100% in addition to the compensation. 31. So, my lord, 31 says rehabilitation and resettlement award for affected families by the collector. The collector shall pass rehabilitation resettlement award for each affected family in terms of the entitlement provided in the second schedule. The rehabilitation and resettlement award shall include all of the following, namely rehabilitation resettlement amount payable, bank account number of the person to which rehabilitation resettlement award amount to be transferred, particulars of house site and house to be allotted, particulars of the land allotted to the displaced item, particulars of one-time subsistence allowance, particulars of payment for cattle shed, particulars of one-time amount artisan and small traders, details of mandatory employment to be provided to the members of the affected families, particulars of any fishing rights and annuity and others, my lord. My lord, this, your lordship will see that this has been, my lord, written that this will be done as per the schedule 2, which is, my lord, second schedule. of which is given under section 31 subsection 1. If I take your lordship directly to the
So if section
yes,
31, the benefits of this section 31
yes,
will be in addition to the compensation and scholarship.
yes, that will be evident in second schedule itself. If I take your lordship to the second schedule, would be there in the back of the book as schedule 2, Roman 2.
Here it has been just second schedule.
Yes, yes, yes.
Section 31(1) and 38(1) and 50.
That great. Now, my lord, kindly skip over to the other parts. Kindly, my lord. One second. But serial number 4, if I take your lordship.
Choice of annuity and or employment.
Yes. The appropriate government.
Give me a second, sir.
I'm sorry.
Yes.
4, it says choice of annuity or employment. It says the entitlement and provision, my lord, says the appropriate government shall ensure the affected families are provided with the following options. A, where jobs are created through the project after providing suitable training and skill development in the required field, make provision for employment at a rate not lower than the minimum wages provided for in any other law for the timing in force to at least one member per affected family in the project, or arrange for a job in such other project as may be required. One-time payment of 5 lakh rupees. Annuity policies shall not be less than 2,000 rupees per month. So, this is the parent provision, and this is the entitlement matrix that has been given here. So,
But there are disjunctive clause with or.
Yes, yes, it does. I tell your lordship here. Now, my lord, in my case, my lord, this particular provision and as also the second schedule, my lord, has been adopted by the dedicated freight corridor itself. That I'll be taking your lordship, my lord, to my writ petition. That this provision is adopted.
If it is adopted, then what is your grievance?
My lord, they are not providing me with this employment. They are saying that I do not have any provision for this. And also, my lord, they are.
Oh, as a policy decision, they have adopted, but they have not implemented in your case.
Absolutely. And my lord, they are. I'll be just coming to your lordship, my lord. Their reply to this, they say that there has been a notification of 2019 which says that we will not be giving this employment. My submission will be, my lord, that cannot override the act as well as the previous decision for implementing. My lord, in my writ petition, my lord, if I request your lordship, my lord, to see, my lord, page number 32.
Mr. Rai, prior to going to that, let us have an academic discussion. So for the implementation of the entitlement and provision, if I again look to the provisions of section 31, Mr. Rai,
My lord.
the collector shall pass an resettlement awards for each affected family in terms of the entitlements provided in the second agreement.
Yes, ma'am.
Now, Mr. Rai, in your case,
Yes.
such award has been passed by the collector.
My lord, has not been. Has not been, my lord. I have been making application. Nothing of that sort, my lord, has been passed. My lord, only compensation that was given, but that compensation was.
No, so I'm not on that.
Yes.
What I'm on. I will come to that point.
I follow
I'm
you.
asking you to for my better understanding.
My lord,
Mr. Rai.
my lord.
What I'm on, section 31 says it is the primary responsibility of the collector to pass rehabilitation and resettlement hours.
Yes.
Am I correct, Mr.
Absolutely.
Rai?
Absolutely.
Now, if I look to the serial number 4 of the second schedule,
My lord.
those says the appropriate government shall ensure the affected families are provided with the following options.
Yes.
Now you are practically on A, 4A.
I am. Yes.
So when the award was collected, when the award was passed by the collector, according to you, the provisions of section 31 has not been, the benefit of provision of section 31 was not given to you, and naturally the requiring body didn't implement the same. That is your contest. Very good. Let
Apart
us-
from the other contention.
Compensation, solar terms, that is a different thing.
So, my lord, thereafter, my lord, lordship, if I request your lordship to come to way number 32 of my writ petition once.
Page number 32. Yes.
But this has been the communication, my lord, of 2015, which has been given by the Railway Board to the DFCCIL's managing director. That it says that above, please find entitlement matrix for DFC.
DFCCIL is the respondent number.
11, my lord.
Your client.
Mine.
What is the full form?
Or it is-
Dedicated Freight OIC. Dedicated Freight Corridor of India Limited.
Yes. So, my lord, this says, may I please, man?
Please, sir.
Yes. So, reference above, please find enclosed entitlement matrix for dedicated freight corridor in accordance with the right to fair compensation and transparency in land acquisition, rehabilitation, resettlement act of 2013, duly approved by the Railway Board. It is requested to take suitable action to disclose the entitlement matrix as per the resettlement policy framework. Then, my lord, kindly, there has been an annexure in this. So, this annex, my lord, the entitlement matrix. The first schedule, my lord, I will not take your lordship to. Lord, kindly comes to, my lord, page number 36. My lord, page number 36. I'm sorry.
Yes.
On page number 36, my lord, provides the resettlement rehabilitation assistance for project affected people. Now, my lord, if I request your lordship to come to page number 37, serial number 4.
Yes, Mr. Rai.
Yes, madam. So here your lordship will see the entitlement that has been, my lord, given in the 1, 2, 3, 4, fourth column, my lord, the last but one column. It says DFCCIL shall provide affected families with employment opportunity where jobs are created through the project after providing them suitable training and skill development in the required field at a rate not lower than minimum wages provided for in any other law for the timing in force to at least one member per affected family in the project, or arrange for a job in such other project as may be required, or one time payment of 5 lakh rupees per affected family, or annuity policies that shall pay not less than 2000 rupees per month per family for 20 years with appropriate indexation of consumer price index for the agricultural laborers. So, and this is the provision, my lord, for providing with the entitlement, my lord, for the rehabilitation and resettlement.
So it is at par with the second schedule.
Absolutely.
It is at par with the second schedule, and this entitlement matrix have been approved by the Railway Board and which has been communicated to the private, the requiring body.
Gotcha. So there is no doubt to that effect that the particular entitlement matrix as well as the schedule has been already adopted by the DFCCIL and, my lord, directed to be adopted also by the Railway Board.
Absolutely.
Now, my lord, if I request your lordship, my lord, to see the report that has been filed, my lord, by my learned friend's client.
Respondent number 11.
11. Because, my lord, I'll be just taking your lordship to the supplementary report, which is the last report filed by them. Because in the first report, your lordship will see, they have just taken the point that we are not the body who can just give the employment to the people. It is only the railway that can give. So, my lord, that submission was already taken care of by this honorable court in the, my lord, in the earlier orders. If your lordship will see that since they are the requiring body, and also, my lord, they have accepted this, so they must have to provide the employment by themselves. And the railway board also, railway also appeared on the earlier time, my lord. My learned senior, my lord, Miss Aparna Ghosh was appearing for the railways. Banerjee, I'm sorry. Yes, Aparna Banerjee was appearing for the railway. So, my lord, be that as it may, my lord, I'll just accordingly, my lord, they were directed to file new report to that effect. And accordingly, this supplementary report, my lord, that was filed. So I'll just relying upon to your lordship to the supplementary report filed by them. This supplementary report is affirmed on 11th June 2024.
Yes, I'm on that.
Yes. So, my lord, they themselves also, my lord, referred the to 2015 letter, which is at page number 8. Along with the entire annexure.
Yes,
Now, my lord, kindly comes to page number 23 once.
23 of the supplementary.
So that, yes, yes, yes. Supplementary report. And the 23.
Memo dated 11/11/2019.
90. They say that by this RBE, which is, my lord, Railway Board circular, by this Railway Board establishment circular, to be correct. By this RBE, my lord, the railway says that from now on there will be no employment to be given to by the in this category in this way. So, my lord, I'll just request your lordship to directly come to serial number 2. Has your lordship got this?
Yes.
The modalities of the implementation of serial number 4 of the second schedule of Act of 2013 were examined by the Ministry of Railways. It has been decided that Ministry of Railways earlier policy of offering appointment to the railway to affected landlords issued with the references above is withdrawn, and circulars issued in this regard with the reference above stands superseded. Lump sum payment of 5 lakh to be provided to the affected families who are primarily dependent on acquired land for a livelihood. That is, cases where their livelihood is affected by such acquisition or where entire land or building of the affected families have been acquired. Thereafter, the mode of considering this grant has been given. So, they say after implementation of this letter, from now we do not provide with the employment anymore. So, I made the submission on the previously when this matter was being taken up by the earlier honorable coordinate bench, that this 2019 letter does not specify any retroactive effect or retrospective effect of this. And my entitlement,
But Mr. Rai, the Act the second schedule provides either or anyone.
yes, that would be my second submission. I'm just coming to your lordship to that. So, in 2019, my lord, this particular provision, my lord, was said to be withdrawn. So, my lord, there is no retrospective effect of this 2019. So, my lord, with respect to the next part of this, the stand taken by them, my lord, about this 5 lakh rupees, my lord. Here, my lord, I just wanted to make some submission, my lord, on the my lord, on the ground of reasonability as well as, my lord, to the tell your lordship that this provision, my lord, whenever subject to your lordship's correction, whenever a particular provision, my lord, of providing an employment assistance or any kind of entitlement as 1, then, my lord, it is as 2, then it is as 3, and all these, my lord, serial numbers like 1, 2, and 3 will be provided, my lord, alternatively. So this provision, my lord, undoubtedly keeps some, my lord, room for the respondent to consider or to use their discretion that what employment or what provision of this 1, 2, 3 would be given to this particular incumbent. So, my lord, my respectful submission before your lordship, this discretion or exercise of this discretion my lord, this has to be, my lord, there on the subjective satisfaction of the respondent. I admit that, but that subjective satisfaction, my lord, has to, my lord, follow with the objective criterion to this. I tell your lordship, here my client before your lordship is a disabled person. So, my lord, this particular, my lord, piece of land which, my lord, he was acquiring, my lord, is an agricultural property, and there was a very short, my lord, small shop room for my lord living his life in that particular premise as well. It was, my lord, the livelihood for the entire families as well, this disabled person. So, my lord, my respectful submission that when they exercise, because we from up to this time, my lord, we do not find any kind of document from the respondents that you are not given this benefit of A because of this reason. Or there is.
Mr. Rai, I'm sorry for the interruption.
I'm sorry.
If we look to the relevant provisions of the second schedule as you referred right now,
My lord.
The language is very clear
Yes.
that you have referred
My lord, schedule 2, my lord, serial number.
serial number 4.
Yes.
The appropriate government shall ensure that the affected families are provided with the following options: A or B or C.
So
There was, please listen to me.
I'm sorry.
There is no indication in this schedule while enactment of the act along with the schedule that if A is not possible, then B will be considered. B is not possible, then C will be considered. So the appropriate government authority have left with 3 options. So if they want to implement B instead of A, if they intend to implement C instead of A and B, if they intend to implement A instead of B and C, where is the unreasonableness?
But it is absolutely right what has fallen from your lordship, my lord, if the appropriate authority is provided with the option. But my lord, kindly sees 4, what is the language of 4?
Yes, sir.
The option is provided to the settlement, the family members. The appropriate government shall ensure that the affected families are provided with the following options. It is not, my lord, the appropriate government will be having the option to provide this thing, A, B, and C. It says the appropriate government shall ensure that the affected families are provided with the following options, which is A, B, and C.
Affected families are provided with the following options.
So, my lord, this is the first, my lord, first part of this exercising of the jurisdiction would be providing me with an option. That is one. Then, my lord, I will be, my lord, placing my option.
The appropriate government shall ensure that the affected families are provided with the following options.
Yes.
A,
it is a mandate.
Or B or C.
Yes. So, well, it is a mandate upon them that they will have to provide us with the option. Unless they do that, my lord, that is the first part of the, my lord, process of resettlement.
No, Mr. Rai, I understand your contention.
Yes. Great.
It is not that, I believe it would be your contention.
Yes.
That the appropriate government will place all the options and they will take one trump card.
Mine.
Would it be your submission?
Yes. That
but is the language is indicative to that?
Subject to correction, yes. Because
The appropriate government shall ensure that the affected families are provided with the following options.
My lord, kindly see the choice of the words by the law framers. The appropriate government shall ensure that the affected families are provided with the following options. My lord, otherwise, if the interpretation that they are trying to take your lordship to right now, the language would have been subject to correction that the appropriate government shall have the option, the following options to be provided to the affected families as below. It says that the appropriate government shall ensure, it is a mandate, shall ensure that the affected families are provided with the following options. They will have to
according to you, Mr. Rai,
yes,
they have to place 3 cards before you. Choice is yours to exercise your option.
My lord.
That is your contention.
Absolutely. Otherwise, my lord, to see it from a different angle, my lord. Otherwise, there would not have been any requirement of, my lord, providing A, B, and C. That would have been completely in their discretion. They would have been given, my lord, they would have given anything about that. So, my lord, my respectful submission before your lordship today, right now, they are coming to your lordship after I filed this petition. My lord, they are coming to your lordship and they are voluntarily that saying that we are ready to pay you 5 lakh rupees. It is not in their hand. It is not in their hand. This is not a legislative mandate. And to my lord, my lord, buttress this, my lord, they have been, my lord, relying upon.
You have prayed for quashing of this letter? No.
No, my lord, no.
Acha.
I just
Very
prayed
good.
for.
You carry on your own.
Sorry. So, my lord, here this is why, my lord, I was they have been, my lord, trying to, my lord, relying upon these letters by showing to your lordship that they are right now not under the mandate of doing this, because it has been, my lord, withdrawn from 2019. It is not under the mandate anymore. Now, also, lordship kindly sees page number 20 of the supplementary report itself. It is a communication of 2010. In fact, this letter, my learned friend Malud will be assisting your lordship why this letter has been annexed here or relied upon, because after this 2010, 2015 has come. It says, this 2010 letter says, pre clause 3. Has your lordship got this one? The last, the bottom paragraph of page number 20. It says that DFCCIL implement the work. There will be no obligation on the DFCCI to take over, improve concession agreement should be clearly specify the state of aspects of the transfer of the suitable provision can be made by the office memorandum on the assets, office and management of the assets of the expiry of the concession. On the next page, any resident,
Any
incident which invites provision of CRS inquiry, existing land down such and such can be instituted, joint investigation. Should not provide any VSA. The model can be structured with the elevator VGF scheme, right-sided by board has directed alignment of route to be present, and action should be initiated immediately for finding PPP and directed discharge by biosensor. So I do not find, my lord, why this letter, my lord, is standing in my way. The next page, which is page number 22, which that is also very much relied upon by them. What you kindly see also. Here, my lord, it is a communication I find from the Joint Secretary of the Land Reforms Department of Government of West Bengal, writes to the district, all the district magistrate and LA collectors. My lord, kindly sees preparation of estimate under section such and such of Act of 2013, directed to convey that in cases of land acquisition where proceedings have been initiated under the Land Acquisition Act 1894 and no order under LA Act 1894 has been made, the following procedure may be followed for preparation of the estimate. Market value, I'll skip over. Factor, solatium, additional compensation, I'll skip over. 5 also skip over. 6. Schedule 2 of Act 13 will not be applicable. All procedure of LA Act such and such will not also be applicable. So this is also another letter, my lord, they have been relying upon on their report. I do not find, my lord, how this letter affects or takes away my right.
No, your property has been acquired following the Act 30 of 2013.
My lord, yes, Railway Act 1989.
1989 Railways Act, my lord.
Yes. The compensation, my lord, right now they are saying that the compensation are being paid in connection with 2013 Act itself.
No, if the acquisition proceeding is done in other act, how do you claim your benefit in this act?
My lord, I tell your lordship, there is a letter of that effect also. I tell your lordship. My lord, fine. I'll just take your lordship to the last page that I was referring to in their annexure, which is page number 27. This is again, my lord, of 2014 letter, which says.
Mr. Rai, please answer to my question first.
I'll take your lordship.
Under which provision of law
Yes.
the acquisition process was initiated and completed?
My lord.
That is
Yes.
that is the main consideration.
Yes, my lord, I'll take your lordship to that.
Schedule 1
He received a notice, was served, and came to the authority under the Railway Act of 1980, published in Bengal Orthoman.
Yes.
So it was initiated under the Railway Act of 1989.
My lord, it was initiated under that act, my lord, admittedly. My lord, about the application of the act, my lord, I'm just taking you lord through the application, because this act, my lord, came into effect in 2013, and my lord, this compensation cases, my lord, have been started, my lord, after that. I'll just take your lordship to the-
Railway Act of 1989 does not prescribe any procedure
my lord,
for determining compensation.
my lord, there was a procedure, but that was not detailed as the act of 2013, which my lord, required the legislation famous, my lord, to come under this. I'll just take your lordship about the applicability in the instant cases, because this has never been the submission, or this has never been the stand of the respondents, that this act does not apply to us. However, I'll just satisfy your lordship to that. But I'll just on the point of law that I'll just make my submission, but only on fact. If I take your lordship, page number 48 of my writ petition, this is one of the latest manner of being agreed by which I have come before this honorable court. Page 48. I apprehend, my lord, if it is not.
It is not. You have not provided any type copy.
I'm sorry, my lord. I ought to have. May I just place your lordship only?
Yes.
Place lordship. Can you do not see, or I'll just place. Gone through the demands placed by the petitioners. Their demand is about some compensation of such and such government job against land acquisition. Verified all documents. It reveals from the award that the award for land value was declared as per the provision laid down in the RFCT LA Act 2013. And notices for payment.
Just a minute. It reveals from the award that award for land value was declared as per provisions laid down in and yes.
For payment of the same, and were served upon the according, but they did not receive the same said account. Instead, petitioner prevented joint survey to carry on such and such. Then now I'll just skip over. It is punishable offense and such to say this, and will be paid to the applicable. Regard the last but 4 line, mother. Regarding claim for having job in lieu of acquired land, it is to be mentioned that as per policy matter, the Railway Board, Ministry of Railways, Government of India, no land acquisition as on today affected people related to TFCC project is eligible to get job in lieu of land acquisition. That was the my lord order.
Subject matter of challenge in the instant.
So my lord, I can on law satisfy to your lordship that this in this process 2013 Act applies, apart from this fact of admission on their part. But on that, my lord, if your lordship wants me, my lord, in that event, I'll just want to make myself prepare on that, because that was never the point, my lord, that was raised either by them, because this has all along been the admitted position. Act of 2013, which will be reflected.
No.
Page number
If
48.
you come to page number 5 of your writ petition,
Yes, ma'am.
there is paragraph 7.
Yes.
Thereafter, the petitioner was issued with a notice dated such and such,
Yes.
whereby he was awarded under section 20A of the Railway Amendment Act 2008.
Yes.
Is somehow rupees 3 lakh
Yes.
7,240.
Yes, ma'am. That was the Amendment Act. The notice was, it is, my lord, I admit that this entire process was
And
started
the
under the Railway Act
So
itself.
you have referred Railway Act of 1989
Yes,
and
does.
Railway Amendment Act 2008.
Yes, it does.
Though they have admitted that award has been,
Granted as per the Act of 2013.
but I am to see
Yes,
that the entire provisions of the 2013 will apply in case of in this case in mutatis mutandis. There is in full
but
full-
about
full existence.
DFCCIL, this act applies, and they have adopted this, that your lordship has already seen in 2015. The letter that I was referring to, your lordship, that the DFCCIL LOA board says that you will have to accept 2013 entitlement matrix, and they say I will do that.
I understand.
In respect to this case, my lord, apart from page number 48, I can satisfy your lordship on the law, but of which I am not prepared to
Not prepared.
on that, my lord, point, because that was never taken by them, my lord. So
No,
this is
how
why
can it be? You must be ought to have been come prepared.
I'm sorry, my lord, that part, because I'm sorry, my lord, I was under the impression that in page number 48 they say that it is the Act of 2013, and they even in their reports they also do not take this point that this act does not apply.
No, prior to granting relief, if you are at all entitled, I am to check that act.
This
Whether
is my
that act
mistake.
is that act adopts the 2013 act fully.
My lord, yes, my lord. I'll just
Come
prepare
prepared, come prepared.
to that, my lord.
My lord, it is totally, my lord, up to the Act of 20F of the Railways Act, my lord. And Railways Act, my lord, there is a provision of arbitration. If your lordship will see section 6,
Railways Act, give me the
section-
book.
then subsection 6 of Railways Act, my lord, Railways Act বোধহয় নেই না
Sir, এখানে quote করে
এটা কোর্ট my lord, I have quoted.
Lord, I have tried to quote Lordship in the first page.
Railways Act is not there.
And
Today I am not carrying Lordship.
our coordinate
Why?
means also, my
20F
lord,
6, my lord.
our coordinate means also, my lord, take this point.
Annex, my lord. Annex A.
Railways Act?
Railways Act 20F, my lord, according to the provision of
Railways Act of
20F.
1989.
Yes, my lord.
My lord.
Lordship sees the amendment, because my lord senior is referring to 20F. That means the
Sabe.
amendment.
My lord, that is
I have annexed,
in
my
the, and our, my lord, coordinate bench, my lord, also passed one order to this, in a similar circumstance, it will go to the arbitrator. There is a provision of arbitration, my lord. If you
Yes.
want to say something, go arbitration.
That may be.
Yes, Mr. Place that, which section you are referring?
Yes, my lord, 6, my lord. That is, my lord, if you are in the context, my lord, section, বইটাই নিয়ে আসুন, বইটা নিয়ে আসুন। 20F6, my lord, subsection 6. If the amount determined by the competent authority under subsection 1, or as the case may be, subsection 3 is not acceptable of either of the parties, the amount shall, on an application by either of the parties, be determined by the arbitrator to be appointed by the central government in such manner as may be prescribed.
It is with respect to the compensation.
That is all the compensation.
This is a part and parcel of the compensation.
Amount, Lordship says the
Uh,
word.
whatever.
I do not have this.
Amount determined, my lord.
That
That is amount determined by the competent authority.
if the amount determined by the competent authority under subsection 1, or as the case may be, subsection 3 is not acceptable to either of the parties, the amount shall, on an application by either of the parties, be determined by the arbitrator to be appointed by the central government in such manner as may be prescribed. The arbitrator cannot have the authority, my lord, to determine whether I will be having the employment or not, subject to correction.
My lord, if your lordship, my learned friend said so, my lord, I want to, my lord, show the provision of that, my lord. That is second schedule. He claims second schedule. My lord, what is the language of the second schedule? Elements of rehabilitation, that is, my lord, second schedule. Resettlement, entitlement for all the affected families. both landowners and families whose livelihood is primarily dependent on land acquired in addition to those provided in first schedule. That is, my lord, that is 4. My learned friend said, the appropriate government shall ensure that the affected families are provided with the following options. My lord, following options. I can give him anything else. My lord, it is not the choice of the affected families, but it is the choice of the authority. Now, my lord, the appropriate government shall ensure that the affected families are provided with the following options. Following options, all the options are odd. Now, my lord, first A, where jobs are created through the project after providing suitable training, where jobs are provided, my lord. My lord, my learned friend, now, my lord, this petition has before your lordship, my lord. Whether the project, my lord, project is not, my lord, continuing. Project continuing. My lord, project is not continuing. What is the meaning of it, my lord? Where jobs are created through the project. If there is no any project, how my learned friend will get the job? Now there is no any project. My lord, there is a first line where jobs are created through the project. If there is no any project, how he can claim that he will get the jobs? And after that, my lord, all the things are or. So he can't claim that I must get A, B, C. For the cause of first things, my lord, the affected families are provided with the following options. If there is no any or, then, my lord, he can claim that I must get all the provisions. So, my lord, petitioner has not any case, my lord.
Which order is under challenge, Mr. Rai?
Uh,
Page number 48.
But in reply to what my lord senior my lord says about the project not is functional, that is absolutely not right. Project is functional. Project has created employment. Several employees are right now working. Entire railway corridors are right now functioning. So that must be put on affidavit if that is my lord the case. One,
Whatever may be that, you have not, arbitration is the, my lord, your procedure is going to the arbitrator, not in here.
and two, I've already replied to your lordship about the option part. Subject to your lordship's correction, my assistance for interpretation.
এটাও বলেছে, এটাও বলেছে। হুম। যে পাতাটা দেখাচ্ছে সেই পাতাটা বের করো না, ওই যে পাতাটা, কোন পাতাটা, কত পাতা দেখাচ্ছ? এই তুমি
কোনটা?
মাইলটকে তো বললে
লাস্ট পেজ, একদম আমার রিট পিটিশনের লাস্ট পেজ।
লিস্ট পিটিশনের লাস্ট পেজ, রিট পিটিশনের তোমাদের অর্ডার এখানে কনসিডার করতে বলেছিল তার এগেনস্টে কি অর্ডার সেই অর্ডারটা চ্যালেঞ্জ করেছে নেই তোমাদের কাছে অর্ডার Mr. Rai, this act is an independent act.
Yes, madam.
It prescribes a mechanism
Yes, madam.
to determine
Yes.
the compensation.
Yes, madam.
That is 20G,
Madam.
criterion for determination of market value of the land.
Yes.
The competent authorities shall adopt the following criteria in assessing and determining the market value of the land.
Madam.
There are, sir.
Right.
It
Yes.
does not say applicability of the Act of 2013.
Your lordship is seeing, my lord, the Railways Act,
Absolutely.
or the amendment.
With amendment.
Yes.
With
that was,
amendment.
That was prior to, my lord, the Act of 2013.
There is also reflection. I'm
Yes.
telling you. 20N, Land Acquisition Act of 1894 not to apply. Nothing in the Land Acquisition Act 1894 shall apply to an acquisition under this act.
That is, my lord, Railway Act. Land acquisition of 1894 will not be applicable in
So
railway.
how do you say that Act 30 of 2013 will have application?
But if your lordship kindly sees, because first my submission before your lordship, this is their contention that my compensation has
Be
been
there as it may. Had it
2014.
been, sir, admission does not create any entitlement. Yes, ma'am. If I say that you are the owner of the, if you are the owner of the Taj Mahal, or if you are the owner of the, if you do not become, you have to prove it on your own.
I must be having, my lord, statutory.
Absolutely.
My lord, kindly sees, my lord, the
Admission does not create any title and does not equally on the same proposition to, of course, subject to
no, my lord,
my
absolutely,
view, it does not create any entitlement there at my admission.
absolutely. My lord, kindly sees, my lord, the preliminary part of Act of 2013.
Which portion, sir?
My lord, Section 1. This act may be called to be the Act of 2013. It extends to the whole of India. It shall come into force on such date with effect from 1st January 2014 with a notification number 19 December 2013 as the central government by notification in the official gazette appoint. So, my lord, this act comes into a play, my lord, in 2014 1st January. Then, my lord, can you see application of the act, Section 2. The provision of this act relating to land acquisition, compensation, rehabilitation, resettlement shall apply when the appropriate government acquires land for its own use, hold and control, including public sector undertaking, public purpose, and shall include the following purposes namely, but A is naval, military, air force, armed forces, national security, defense, such and such. B, for infrastructure projects, which includes the following, namely, all activities items listed in the notification of Government of India of 2012. So, my lord, I do not have the document, but I can show your lordship from 2012, the DFCCIL is included in it. But I will take your lordship to that. However, excluding private owners and such, projects involving agro processing, project for industrial corridors of mining activities, national investment, manufacturing zones, project for water harvesting, administered government aided education, project for sports healthcare, any infrastructure facility as may be notified in this regard by the central government after tabling such notification in the parliament, project for project affected families, project for housing income groups in time to time, for planned development of improvement of village sites, site of the urban areas, project for residential purposes of poor landless persons and such and such. The provision of this act relating to the land acquisition, consent, compensation, rehabilitation, resettlement shall also apply when the appropriate government acquires land for the following purpose, namely for public-private partnership project, which is the DFCCIL, where the ownership of the land continues to vest to the government for public purpose as defined in subsection 1. Provided that in the case of acquisition for private company, public-private partnership project, the clause 2, public-private partnership project, the prior consent of at least 70% of those affected family as defined shall be obtained through a process as will be described, provided the process of obtaining consent shall be carried such and such. No land shall be transferred, such and such. The provision of the subsection 3, provision of relating to Rehabilitation Settlement Act shall apply to cases where a private company purchase is not applicable. Private company request not applicable. So, my lord, here it is, my lord, it is their case itself that it is, my lord, a public-private partnership project, PPP project.
My lord, may I be interfere in this matter? My lord, main thing, my lord, your lordship passed the order in the previously National Highway Act, my lord. Same provision is here, my lord. There is, my lord, 3G1, 3G5, and 3G6. There is arbitration clause and 3G. That is the provision. Your lordship passed that order on that this court has not any jurisdiction when the order was passed. And in this matter, my lord, that is 20F, that is 20G, my lord. There is a provision how the matter was there, my lord.
No,
and
Mr. De.
Yes, my lord. There is arbitration clause.
I understand your contention. But if we look to the chapter 4 and chapter 5, we find separate components. Determination of amount of
That
compensation
is
under
the
section
National Highway Act,
27
similar to the National
Absolutely.
Highway Act, separate
and
component.
determination of the value of things and award of solatium. This is one part. Then comes chapter 5, the rehabilitation settlement award. So he is challenging for not granting relief under chapter 5.
My lord, I am not on that point. My point is that the petition is not maintainable here. He must go there.
I
according to
understand
the
your
statutory
contention.
part. Statutory provision is there, my lord. Statute, my lord, there is a provision. The 20F and after that, my lord, 20G, you go to the arbitration.
This act came into force on?
Act of 2013.
Yes.
1st
That is
January
first day of-
2014.
1st January 2014.
Yes, ma'am.
Where from will get that?
Section 1, or there would be, my lord, a asterisk mark at the bottom.
Published.
Date of enforcement is with effect from January 1,
Yes.
2014.
Yes.
And when your land was acquired?
Or the date of acquirement of land, my lord, I think. But I was issued with the process notice on 20th September 2021.
No. When the
Land was acquired.
acquisition took place,
I tell you.
that is very relevant.
And, I find that the petition of state notice was served on 10th of December 2016 on the petitioner, as Lordship has seen paragraph number 4 already. But I have mentioned Railway Act 1989. And the paper publication was 12th of October 2017.
16.
And the LA case number was of 2016.
The publication of the declaration land sale based absolutely in the state government. So when the declaration notice was published, have you indicated in your report
My lord,
when this was for the Union of India? This for the Union of India. Where is Madam Aparna Banerjee?
my lord, she is appearing for the railways, but today she is.
When 20 notification was published, that I intend to see.
As per my contention, my lord, the publication was.
No, your contention will not serve your purpose.
My lord.
You have to show when this notification has been published.
Yes, my lord. Their report, my lord, I find their report of this TFCCI supplementary report, your lordship has seen.
And the operation of the process of Hattu was published in the government of publication 20A, 20A1.
My lord is on the report. Or page number 4, my lord, sees once.
It was published on 2016.
Yes.
14/7/2016.
My lord.
Declaration under section 20E1
My lord.
was published on 14/7/2016.
My lord.
That is the date of effect of amendment.
My lord. Or kindly sees, my lord, page number 4 of the report once. Supplementary report by them, DFCCI.
Yes.
And second paragraph starts with moreover. Moreover, the subject land has been acquired for a stretch of DFCCIL project which is planned on public-private partnership model. And thus, creation of job in this section do not fall within the purview of DFCCIL. So that comes under the definition of Act of 2013, as your lordship has already seen, 2 subsection 2 clause A. Then, my lord, kindly sees, my lord, the letter.
Mr. Wood, I wait for some time.
Sorry, I'm so sorry.
Mr. De, I request you to look to the provisions of section 27 and 31 along with first schedule and the second schedule. Now, Mr. Dev, section 27 says determination of amount of compensation. Am I correct, sir?
Yes.
28 is parameters to be considered by the collector in determination of the award. Award means towards compensation.
Yes, ma'am.
Next is determination of the value of things attached to the land or building, which will be also a determining factor for determining the compensation.
Yes, my lord.
Now, section 30 is award of solatium.
100% solution.
That is also a component of the compensation.
Yes, ma'am.
Chapter 4 ends there. Now, sir, please come to first schedule. That is, in terms of section 30 within bracket 2, compensation for landowners.
Yes, ma'am.
How it has been done, it has been elaborately discussed.
Yes, ma'am.
Now, sir, come to chapter 5, rehabilitation and resettlement award. Rehabilitation and resettlement award for affected families by collector. This is, the details has been discussed in the second schedule. So apart from compensation, rehabilitation and resettlement award is a separate component. I'm sorry, separate thing which are to be awarded. It cannot be mingled up with the compensation. So if your contention, if I accept your contention that in case of inadequacy of compensation, their remedy lies before the arbitrator under the Railways Act. That I understand. But what would be your answer with regard to the alleged entitlement of the writ petition under section 31?
That is, my lord, if that is so, my lord, High Court is not the forum. That is the forum is, my lord, that is the DM, collector. Collector is the authority. If your lordship thinks that one component has already done, but another component was not, my lord, was not passed by the collector. Your lords admit. Your lordship, my lord, according to your lordships, my lord, one component has already done by the collector. Another component was not, my lord, done by the collector. In my view, my lord, according to your lordship's view also, in National Highways Act, my lord, there is a similar view that 3G1 and 3G5, if there is no, all the components was there, whether he can come before the Honorable High Court or he will go to the arbitrator. Here is also, my lord, there is arbitration clause. So, my lord, and your lordship passed that order that whatever may be that, he must go to the arbitrator according to 3G6, not here.
National Highways Act.
If your lordship will see the National Act, this is the independent act, my lord. If this is not independent
National
act,
Highways Act.
National Highway Act.
National Highways Act. G5.
Yes, my lord.
Read, if the amount determined by the competent authority.
Under subsection 1 or subsection 2 is not acceptable to either of the parties, the amount shall on an application by either of the parties be determined by the arbitrator to be appointed by the central government.
We are here. We are not.
Same
We are
thing.
not on compensation, sir.
My lord, same thing.
Here
My
we are.
lord,
We are. We
my-
are
my
on
lord,
the. Here we are on the chapter 5.
My lord, in that case, my lord, chapter 5 is always there. In National Highway Act, in here, in Railway Act.
No.
In the-
National Highways Act does not provide for any rehabilitation and resettlement award.
If the 2013 Act is there, my lord, all the things were components were there. If National Act, মানে 2013 is applicable in the National Highway Act.
Section 3G heading deals with the determination of the amount payable as compensation.
I know, my lord.
Sir, we are not on compensation. We are on whether Mr. Rai is on is entitlement regarding rehabilitation and resettlement award.
That is the another component. Two components is there. What, my lord?
I understand your contention.
Yes, ma'am.
Yes, madam, what have you got to say?
My lord, the acquisition has been done under the Railways Act 1989, lordship. I have just handed over. Have your lordship got it, my lord? 20F6 and 20F7, those are the provisions. The petitioner can approach before the arbitrator. And the one more thing, Malad, the coordinate bench of this Honorable High Court recently has passed on the self-same cause of fact, self-same point that the petitioner will first go to the arbitrator and then come before the re-jurisdiction, Malad. I have handed over, Malad. Malad, the project is not running, lordship. So there is no job generation as of now.
Where you have stated that? In which you have filed your report and supplementary report. Where you have stated that? Which paragraph that has been stated?
Malad, my supplementary affidavit, paragraph, page 4, para 2. Moreover, lordship got it, Malad?
Yes.
Moreover, the subject land has been
Page
acquired.
number?
Page number 4, Malad.
Page number 4. I'm sorry. Yes.
Page number 4, para 2, lordship.
Yes.
Moreover, the subject land has been acquired for a stretch of DFCCIL project, which is planned for public partnership model, and thus creation of job in this section, if any, do not fall within the purview of the DFCCIL. So, Malad, this is still in the absence of any employment generation under its control. Employment opportunities cannot be made available to landowners whose land is acquired. As such, option of employment under serial number 4 is not available, feasible. Accordingly, other options enumerated in serial number 4 of the second schedule are available and to be explored by the competent authority, land acquisition Kala. So, Malad, under this act, the authority, definition of authority is defined under 3F. Is the authority means land acquisition? 3F of the Malad, land acquisition and rehabilitation resettlement act, Malad. Have you got it?
Yes, sir.
3F.
The Land Acquisition Rehabilitation Resettlement Authority.
Authority means, Malad, authority means land acquisition and rehabilitation and resettlement authority established under section 51. Collector. Collector means the collector of the revenue district includes deputy commissioner and officer specially designated by the appropriate government to perform the. So it's not the DFCCIL, Malad. We are the requiring body. The state government will be, state government will determine, we will, if state government thinks that the compensation to be paid to the petitioner, we will be giving the payment to the state government and state government will be making payment directly to the petitioner. It's not the case we will be making direct payment to the petitioner, Madam.
So who is the appropriate authority?
That is the competent authority, my lord.
Who is the competent authority?
I am the-
State government is the
State government is
competent
No, which respondent?
DM, district magistrate.
DM lordship.
Respondent number 3.
Just a minute, my lord.
Authority means the land acquisition, rehabilitation.
No, no. ওটা না ওটা না এই তো এখানেই পাবে তো কালেক্টর 3 my lord.
Respondent number 3 lordship.
That I'm seeing.
My lord.
এই আসুন
I already had just got a copy, my lord, where, my lord, it has been admitted by the railway that the Act of 2013 will be applicable in the railway acquisition. Already had. Lordship would also see on section 105. I did not, I missed to take your lordship to that. Great. But the next two matters, my lord, are same. Yes.
Item number 3 million, I am appearing for the states, and item number 4, Mr. Day is appearing. Similar. Can it be disposed of by a common order?
Yes, ma'am. The rejection dates are also same. The order impugned.
The date, whether the plot number is different.
Plot number, lordship has not
Whether
mentioned.
different.
Lordship has not mentioned any plot number.
But the acquisition case number is same.
Same.
You, my lord, your lordship directed, given the order, pass the order, 3 and 4.
My lord, in 3 and 4, they have not used exception to our report. What they have used in item number 2.
I'm just giving up.
So
Provide your lordship's officer, my lord, two other matters which are not listed in this matter. Provide your lordship.
Sets of lawyers are
Listed.
No, that will be recorded. তুমি ওইগুলো একটু ঢুকিয়ে নাও তারপর দেখছি
And I'm just handing up to your lordship's officer, my lord, two other writ petitions which are pending but not listed today. So let it come to your lordship, please, whenever your lordship pleases, and thereafter I'll place this order.
ভেরি গুড সেকেন্ড হাফ ইন দ্য সেকেন্ড হাফ আমরা কি নিচ্ছি আজকে
Adjournment will not be taken up.
second half I don't know how long the
No, adjournment of the 20th.
no adjourn motions will not
The next one, this,
তাহলে
my
একটা
matter
কাজ করবে।
item 5.
your matter is item 5
Item 5 on next Friday, man, fix it next Friday.
Now my knowledge will make some submission.
My lord, may I indicate one thing? Today
Hey,
is
Bhagwan,
3:30.
Today 3:30.
My lord, may I indicate one thing? Now, my lord, my matter is under the new motion. Last item number 32. I'm watching this matter for last entire week, and my client is poking me when the matter will be taken up. I know, my lord, what I'm praying, subject to Lord's kind consideration. No. No. I am not saying this. Why can I blame the court? How can I blame the court? I'm a product of this institution. I cannot blame this court. No matter what I'm proposing, subject to Lordship kind consideration, your Lordship takes up it. That
Somewhere
my
it's a
lord,
long matter, big matter.
Well,
When it is
what I'm
this problem,
submitting,
it's a
your
big
Lordship
matter.
taking up the land motions regularly in the first half, but it cannot reach new motion. If your Lordship takes up new motion in one day, instead of fixed motion and land motions. Then, my lord, your Lordship kindly place my matter in the fixed motion 32, because my matter because your Lordship kindly see the urgency. It is a land loser's case, and all my clients are all senior citizens.
Maybe permitted to mention my election application, which was marked as part heard before your lordship. Lordship, last time we mentioned the matter, your lordship had indicated that due to the caseload, he won't be able to take it up and he release it. But it's not
Part heard. It's very, very difficult for me to take up.
very well, my lords, but the matter is not getting listed.
Yes, yes, absolutely. এটা নিয়ে নাও তুমি আগামী মানে নেক্সট ফ্রাইডে তুমি মেনশনটা দিয়ে দাও। আরে আমার কাছে বলছেন পার্ট হার্ট আছে, দেখে দিন না পার্ট হার্ট।
Is any possibility to take up the appellate side matter again, my lord? The 330 is there.
Chance is bleak, but I cannot say.
330
I'll not say that I will not take up the will not take up matter.
Today is 330
But
and again.
at much I can say, I will not pass any adverse order. That much I can assure. That assurance I can give.
But 330 is there and Fridays. Appellate side.
Original.
No. Then again. Get.
Item number 1.
Victory appearance state respondents.
All the 12 matters have been completed.
Take down. It's submitted on behalf of the petition.
My lord, we are for the respondent led by Mr. Satyajit Malik, the lordship.
আলাদা করার কোনো who is appearing?
He may not be petitioner. He is the applicant in CAN. Petitioner none appears. Nobody is here.
Very good. Pass over.
He wants to be added.
Who's for the petitioner?
Petitioner is not here.
5 minutes pass over.
Very good. Pass over. Next.
For hearing item number 40, representation of the proprietor of the transport paper.
Where is KMC? Moish.
Next Friday.
Proceeding in his absence won't help because he will not get the submissions. He'll again come and say resubmit.
The respondent is not represented. Very good. Not today. Next Friday it will appear. Okay. Yes, password. Call the password now, my matter. Item number 13.
I'm sorry, Milord. I'm sorry, Mr. Chatterjee is for the repetition.
Oh,
Can has been filed, can 9 by someone else.
it's GA. We are now in original side.
Original site.
GA9 is whose application?
That's an application for addition of party filed by Milord, one person who says I am the owner of the property. That is his main contention is in GA9. Now, like your lordship, before opening the brief, Milord, on the GA. Now, Milord, what happened, Milord? Previously, there were several applications, Milord, for addition of parties. Same contention that this was the property originally of Rani Rashmuni. Then, Milord, they are the heirs. Now, Milord, Honorable Justice Vivek Chaudhary, as his lordship then was in this court, has taken up GA8. My lord will find the order sheet also. In GA8, my lord, his lordship held the claim of the ownership of the applicant is not the subject matter here. So therefore, he need not be a party addition in the writ petition. Then another class of person comes now in GA9.
What is the read for?
Read for, my lord, praying for setting aside the acquisition which is bad in law.
Acquisition under?
Under, my lord, Requisition and Acquisition Act 2.
Of 1948.
1948. Now, my lord, we have exchanged our affidavits.
Yeah.
The KMD has filed its affidavit, state has filed its affidavit.
Where has filed GA9?
GA9, my lord,
GA9 to be heard first.
My lord, I tell your lordship, my lord, whether if it is hold that the acquisition is bad in law, then, my lord, if he is the owner, he will fight out in the title suit.
No, that's a
No problem.
GA9 of 2024.
Yes.
No.
Definitely, it was transferred. His lordship was transferred. From that stage, now, my lord, we are in a fresh hearing. Will be starting. We are almost at the verge of completion.
Over this land. Over this land, there is a series of litigations, one after another.
Litigation is going on in a first appeal, my lord, with Holdiram with KMDA. Right, I'll take that point in this also. Absolutely malafide action.
For the petitioner, Lordship. Lordship, praying for not this week, Lordship. It's Friday, Lordship. 15 days time, Lordship. Please give. No, Lordship. Lordship.
File the order books of the order book. 2022 matter.
Yes. The application GA1 and GA2 is allowed, Lordship. This is.
Mr. Ghosh, you are late.
I could not think, my lord, that 14 and 15 would be taken up within 9 minutes after 2. Just asking my to
Next week. Come next week.
Fine.
Who is the advocate on record?
Lordship, advocate on record is
Jane Manna.
yes, Lordship.
Who is your counsel?
Shomit Rudran Mahendra Prasad Gupta is the counsel, Lordship.
Where is the order under challenge? Memo under letter under challenge? Where is that?
Lordship, I have not any instruction,
Then
Lordship.
why have come? Why have come then? Without instruction, why have come?
Sorry, Lordship, but Lordship.
No sorry.
Pardon me,
Why
Lordship.
do I accept your sorry?
Pardon me, Lordship. Give me 2 days, Lordship.
I want to see the letter which is under challenge. Where is that?
Actually, my lord,
Sir, if you don't know the case, don't appear.
no. Actually, problem is the erstwhile advocate.
Sir, problem is yours, not with the court. I want to see the order which is challenge and
We have not received all the papers, my lord. That's why you are paying time, my lord. We have not received all the papers. I'm handicapped, man. Really.
মামলার দিনে মামলা করার নাম। আচ্ছা এটা তো ডিসমিস বা ডিফল্ট হয়েছিল এলো কি করে?
It has been restored.
সে অর্ডার কোথায়?
Last order, Lordship.
Last order. It has been restored, my lord.
Last order.
ওইখানে রেখে দিয়েছেন কেন তাহলে? হ্যাঁ? On all occasion, matter is getting adjourned. All occasion.
What steps are taken by the astral advocate on record? We don't know. That's why
Report in the form of affidavit submitted on behalf of the respondent 2 to 5 is taken on record. 2 to 5 কি আছে দেখি? Who is for the state? এ দেখি স্টেটের এটা দেখি রিপোর্টটা দেখি তো। পরিতোষী না। Respondent state is not represented on behalf of
Next week I shall start dismissing. Thereafter dismissal. But I pray, my lord, one thing. Your lordship will hear the motion, my lord. My lord, this is a motion court. This is not a hearing court, my lord. According to us, is there, what can be done? Your lordship can take the determination, but your lordship can fix one day for the hearing. As because, my lord, fixed matter is a hearing matter, and other matters also, well, in every matter are hearing matters, my lord. Those matters will not be. My lord, motion is, my lord, is a line. Whatever will be that, my lord, your lordship can take the motion. Motion, my lord, is neglected by. My lord, your lord, I take up the only days of no, my lord, that is not the motion. That is the fixed matter. That is a hearing matter. That is the yes, my lord. Every fixed motion, every fixed motion is a hearing matter, my lord. After report and anything else, my lord. In other court, my lord, fixed matter is, my lord, hearing matter. But in this court, my lord, so motion will there be a. So, my lord, your lordship should consider that motion will be disposed of by your lordship. Yes, my lord, your lordship dispose of every matter, but I pray that your lordship dispose of some motions first. Fixed matter are other things, and we do not keep any matter pending. Only for that reason, my lord, the motions will be neglected. Only for this. Anyway, all the matter. Call the list. Let me see. Hey, I'm a list. Motion পাওয়া যাবে না আর motion একটা লোক নেই number 6
Go on calling.
number 7 number 8 9
My lord, I'm for the petitioner, my lord.
Who's for the state?
Report the my lord. There is a direction to file, my lord, the court. I'm filing, my lord. It was a copy.
No.
Reporter copy.
No. And my lord, we are filing a supplementary affidavit in this matter, my lord.
The report. Copy down
Yes, I will.
Liberty was given.
Well, supplementary affidavit.
Hey,
Why supplementary affidavit?
আপনার জন্য leave নিতে হয় কোর্টের কাছে
Oh.
মাইলরের কাছে leave না
My lord, actually, there were certain facts which was upgraded later on after filing the matter.
No, I shall consider why you are filing.
Yes, my
What
lord.
is the wait, give me a second.
Okay.
আপনি তো এই মাত্র ওরা দিল আবার দেখতে হবে কি করছে
Yes, what is your case?
My lord, the case of the petitioner in short is that, my lord, the petitioner is the highest bidder in an e-auction process which was bloated by the respondent authorities, my lord.
Sorry?
In an e-auction process, my lord, for grant of
You are the highest bidder.
Yes, my lord, I am the highest bidder and I deposited 1/3 of the bid amount, that is amount of rupees 7,03,534 on 19th December 2018, my lord. Subsequently, my lord, letter of intent was issued on 8th of January 2019.
You deposited the bid amount, 1/3 of the bid amount.
My lord, I have deposited 1/3 of the bid amount and thereafter the LOI was issued in my favor.
The LOI was issued.
Yes, my lord.
Yes, letter of intent
Annexure
was issued
P1, my
then.
lord. Thereafter, my lord, the petitioner submitted.
not rejected
Yes, my lord, it was issued. It is made annexure P1 to the writ petition, my lord.
Yes, please press your case.
Yes, my lord. Thereafter, my lord, petitioner submitted application before the authorities, my lord, seeking environment clearance, which was seeking environment clearance, my lord, and the application was pending. That's why we moved. We preferred application.
Environmental clearance is given by the state authority.
Yes, my lord. Later on, we had submitted before the state authorities also seeking environment clearance, and in a meeting, in a minutes of 60-second meeting held by the state authorities, at page 50, my lord, my application was rejected upon making several observations, my lord, kindly
No, you obtained the environment clearance certificate.
clearance was not granted, my lord. We had made several applications, but environment clearance.
No, environment the appropriate. Who is the appropriate authority for granting?
My lord, SIA, my lord, state authorities.
Huh?
State level environment impact assessment authority, my lord.
Huh?
SIA is the appropriate authority for granting of environment clearance. So we submitted applications in the state in the previous portal also as required. But my lord, it was till now, my lord, till date, the application could not be granted. The environment clearance could not be granted, my lord.
Then what happened?
Thereafter, my lord, as the application, my application was rejected in a 60-second meeting, which was held by the state.
That is under challenge.
Yes, my lord. That is also the fact is that, my lord, they rejected my application by taking several observations. It is at page 50, my lord.
Place the observations.
SIAC observation and recommendation. The ACAC observed that the consultant who appeared along with the project proponent did not have valid accreditation certificate from NAVET. Also, the plot area for the proposed project as per the approved mining plan and application form does not fall within the potential zone of the approved DSR. Also, PP has not uploaded original LOI showing, my lord. Your lordship got it, my lord?
Give me a second. Did not have valid accreditation certificate.
Yes, my lord. To that,
then
my lord,
proposed area of the proposed as per approved mining plan and then does not fall within the potential zone of the approved district survey report.
yes, my lord.
PP has not subloaded the original LOI showing the plot location and cluster certificate.
My lord.
So what wrong has been done?
My lord, the fact is that, my lord, the project proponent who, the consultant who appeared with the project proponent had a valid, submitted a representation wherein it is shown that he had valid, my lord, kindly turn to page 64, my lord, your lordship. Be pleased to. My lord, actually, my lord, it's in page 51, my lord. Kindly see, my lord. It's in page 51, wherein the Mr. Dr. Tuhin Roy, the consultant of your petitioner, my lord, submitted a representation to the supporting staff ACAC, my lord, stating that, kindly see the second paragraph, my lord. I say that pertaining to the EIA notification of MOEF dated 15th January 2016, in point 7 of Appendix 11, procedure for environment clearance for mining of minerals, including categories, mentioned that for category B2 project, mining of minor minerals shall be prepared by the registered qualified person or accredited consultant of Quality Council of India, my lord. So, my lord, the consultant who was there with the petitioner is a registered qualified person as per the notification, as per the representation which the consultant has submitted before the ACAC, my lord. Then, my lord, kindly see page 62, my lord. Kindly see. This is the certificate of accreditation of the. He submitted this to page 62, my lord. And, my lord, and whole clarification was made by further representation, that is at page 64. It was also submitted by the by Dr. Tuhin Roy, my lord, who was the consultant, wherein, my lord, in the below portion, later on, may I read it, my lord?
Yes,
my lord. Page 64, the below portion, my lord. Later on, 17th January 2023, I submitted an application along with the said notification and also the accreditation certificate of my mother concern accredited company named Ecotech Labs Private Limited, as was asked in the ACAC meeting. But somehow, due to some miscommunications in the uploaded minutes of the said meeting, which was uploaded on 24th January 2023, there is no reflection of the said notification nor the certificate I submitted. Instead, the observation and recommendation of ACAC read as under that the consultant who appeared along with the PP did not have valid accreditation certificate from the NABET. That in the said recommendation, it has also been mentioned that the plot area of the approved mining plan does not fall within the potential zone of the DSR. That in the said recommendation, it has also been mentioned that the PP has not uploaded LOI showing the plot location and cluster certificate from the competent authority, which was neither asked in the meeting or any EDS or ADS given to upload it. Well, these were the points which was observed while rejecting my application, my lord. And Dr. Tuhin Rai, the consultant, clarified the whole thing, my lord, upon submitting this representation, which has been annexed to the writ petition at page 64, my lord. Now, my lord, so far as the supplementary affidavit, my lord, kindly see, my lord, page 6 of the supplementary affidavit, annexer P9, my lord, wherein a notice was issued by the additional district magistrate and district land and land reforms officer, my lord, and stated wherein it was stated that the all interested persons who are requested to submit claims and objections for finalization of the DSR within 30 days, my lord. My plot location was rejected on the by saying that it does not fall in the potential zone, my lord. So I when the notice was issued by the additional district magistrate, district land and land reforms officer, my lord, I requested to include my sand block in the potential zone at page 7, my lord, annexer P20. Page 7 of the supplementary affidavit, my lord. Therein it was requested to include my sand in the potential zone. My lord, I had been the highest bidder, my lord. I had deposited a huge amount of money.
Your application was rejected in the meantime.
In the meantime, my lord, challenging the rejection of the ACSC, my lord, which
Then what is your prayer in the writ petition?
yes, my lord, to grant me an alternative plot of land having equal deposit of sand, my lord, or inclusion in the potential zone, my lord. Anyone, my lord.
No. You are agreed with which order?
I am agreed with the ACSC meeting held that order, my lord. That is annexed piece.
The grounds is that you do not have any valid accreditation certificate.
Yes, my lord. But
you saw that it is with you.
Yes, ma'am.
But it could not be shown at that time, at the time of meeting.
No, my lord. Valid accreditation certificate
and does not form under the potential zone.
Yes, my lord. It was not asked
And
at the
PP,
time.
what is PP for?
Project proponent, my lord.
Yes, Mr. Waterpal. Just now it appears from a report, my lord. Can you see my report?
Where is your report?
Just now I have submitted.
My lord, I did not get a copy of the report yet.
Which?
Thank you.
Page 3, paragraph D, my lord.
Page
3, paragraph D.
Page 3.
Yes. After approval of the district survey report, the writ petitioner applied for environment clearance, and in that 62-second meeting of state level expert appraisal committee, that is ACAC, held on 11th of January 2023. As per the document submitted by the petitioner, it is seen that the application of the petitioner was rejected on the grounds the ACAC observed that the consultant who appeared along with the project proponent did not have valid accreditation certificate from NABET. Also, the plot area for the proposed project coordinates as per the approved mining plan, an application form does not fall in the potential mining zone recorded in the approved district survey report of Purba Bardhaman district. Also, the PP has not uploaded the LOI and cluster certificate from the competent authority. These are the grounds on the basis of which his application is rejected.
That I have stated, my lord, before your lordship, and I have given valid submissions.
And my lord, they have annexed. My kindly see the page, my lord, 5, paragraph G. Paragraph G, my lord. As per order of Honorable Supreme Court in Civil Appeal number such and such, the MOEF, Ministry of Environment Forest, had issued enforcement and monitoring guidelines for sand mining in the month of January 2020, wherein it has been stated to prepare the DSR, that's in the district survey report, as per the procedure and parameters laid down in the policy of January 2020. Moreover, the draft DSR is to be approved by ACAC, State Level Expert Committee, and ACIAA,
district survey is prepared before grant of environment clearance as a preventive measure so that mining does not hamper the ecological balance of the environment. Hence, in case the writ petitioner has not dispute with the district survey report, he may approach the appropriate authority for review of the district survey report. Because the district survey is against him, my lord.
Well, it is not. It does not fall in the potential zone. That's why, my lord, as per the notification made in the supplementary
And
affidavit, we have
next
prayed for
paragraph,
review
my
of
lord,
the
can you
same
see?
also.
Next paragraph, paragraph H. Well, it is a known fact that river changes its course often. So to do some extent, potentiality of the sand block depends on the availability of sand. It is also pertinent to mention that the auction was held on 2nd of December 2018 and the DSR has been prepared in the month of August 2022, nearly after 3 years, 8 months. So there is every possibility of change in course of river and or availability of mineral reserve. So in such a case, the writ petitioner had every option to apply for review of the district survey report or apply for alternate mining plan, revising its geo coordinates without changing the plots and not exceeding the total area as allotted through auction and mining plan, rather than applying for shifting the sand block, which is not permissible as per Rule 38 of the West Bengal Mineral Concession Rule 2016 and Rule 4 of the West Bengal Sand Mining Such Rules 2021. Moreover, as per the said rule, e-auction is mandatory before letting out any sand block. The next paragraph, my lord, paragraph I.
So you have got no objection if SIA is review the matter.
Yes.
You have got no objection.
He may apply for the review.
My lord, I have applied for review in the supplementary affidavit. We have applied for review, my lord. It's 7, my lord. I would like to highlight the present situation of aforesaid sand block indicates availability of sand block. Given this, you are kindly requested to review and
Where is
include-
that?
My lord, page 7 of supplementary affidavit, my lord. না supplementary affidavit আমরা representationটা করেছিলাম না ওইটা বলছিলাম
Where is the review?
my lord, I have requested for review, my lord, as per the
Requested review for before whom?
before the district magistrate.
District magistrate is not the authority.
Oh, my lord,
His LOI was not cancelled as yet.
LOI was extended time to time, my lord.
That has been
Extended.
Yes.
My lord, I have deposited huge amount, my lord. I have been the highest bidder. I don't find my fault. Is not keeping the supplementary affidavit on record.
It has been taken on record.
Obliged.
Item number 7 and 8 got passed over, my lord. We thought matter won't be taken up.
7, 8.
7, 8, my lord, I've been.
First one, no, not today.
State advocate is present, my lord.
You are for?
I am for the petitioner.
Who is for the state? So why are you standing there? Come this side.
No.
Same order.
I'm covered by my lord's order already. Yesterday, Mr. Banerjee was mentioning 2 matters, my lord, because I'm covered by my lord's order. Kindly see the file, my lord. I am polishing the sand. I'm buying the sand from
Oh,
the,
that matter, that matter. Where is the order?
that is annexed, page 26, annexed P5.
Report is filed. You are submitting report.
Yeah, I will submit.
Photo matters.
Why 2 sets?
2 matters, my lord.
একটা করে দাও।
7 and 8.
7 and 8.
প্রথম, মানে first one is WPA
Give
1.
Mr. Dhar, give me a second. Prayer is same.
I have all the required licenses, even road challans, everything is annexed. GST, everything. রিপোর্টটা দেন না। Yeah, that's good. And I'm taking a copy of the report. Even report, last paragraph of the report says there is no objection from this end if the petitioner runs his business after maintaining all necessary relevant legal formalities notified by the government.
You are not stocking parallelly. You receive the
Yes, Manat. If I am permitted to Manat submit those who get those who are the highest bidders, they are allowed to stock. And after they excavate from the riverbed, they get the license from the appropriate authority. Then they do they do get the challans, e-challans for transporting that sand. And Manat, this sand comes to my factory where I polish this sand and for the purpose of filter.
No, where from you get the sand?
From the auction purchaser. We have to buy that sand. Our job is completely different. Manat, kindly come to page 24. Manat will get the answer. Yes. Even I wrote to the West Bengal Mineral Development Trading Corporation Limited. Kindly come to second paragraph or third. The natural river sand is brought from authorized mine owners of sand ghats. After paying the royalty and getting regularized mining challans, the material is then transported through tractors to our unit where the grading of sand is done through different meshes and different grades produced.
এইখানে এইটা চেঞ্জ হবে এই যে রিপোর্ট ডেটেড সাবমিটসের রিপোর্ট ডেটেড এটা হবে হচ্ছে আপনার 18/6/2025 হবে 18/6/2025 হ্যাঁ আর এটারও হবে
এটাও বলে দিয়েছি
এটারও সেম ডেট হবে
MSME, GST, everything.
এর নামটা চেঞ্জ হয়ে যাবে মিস্টার ব্যানার্জির নামটা চেঞ্জ হবে What is the name of the farm?
This is kindly come to straight away to page 24. There Lokhi soft coke.
এটা হয়ে যাবে লক্ষ্মী সফট কোক হ্যাঁ লক্ষ্মী মেসার্স লক্ষ্মী স্টপ কোক এইখানে পেয়ে যাবে এই যে লক্ষ্মী সফট কোক মা লক্ষ্মী Mr. Dhar,
sorry.
Messrs. Ma Lakshmi Soft Coke and Coke Boutique, Coke Briquette. এইটা পেয়ে যাবে এইখান থেকে
মা লক্ষ্মী
এটা হলো
না মা আলাদা হচ্ছে এর
No interlocutory application is there, no?
No.
এটা হচ্ছে মা
Respondent numbers are same.
Same.
দেখেন রেসপন্ডেন্ট দেখেন
মা লক্ষ্মী soft coke.
রেসপন্ডেন্ট দেখেন the same no respondent
মা লক্ষ্মী soft coke
8
and Coke Boutique না কি রয়েছে
নয় এটা 4-6 ছিল আগে
এইটার হচ্ছে না
নাম্বার 4-6 ছিল
Respondent number are different. 6 and 8.
6 আর 8 হবে
It should be 6 and 8.
6 and 8. Officer in charge আর BLL আর 6 and 8. তোরটা তোমারটা দেখে না
ওইটাই আচ্ছা ঠিক আছে এখানে 80 হবে
এখানে the date of the report would be different.
Yes.
And the name of the learned advocate for the state would be different.
Yes.
Paragraph number 7.
Both are Banerjee. This is
Oh, very good.
No, no, no. That was Joydeep Banerjee. And this is
And
Deep Narayan
and
Banerjee.
page number 29, instead of Mrs. Rudronil processing Mahalakshmi.
Yes, Mahalakshmi.
And paragraph 14, respondent number 4 and 6, it will be respondent number 6 and
6 and 8.
And WPA number will change.
Yes.
No. Paragraph number 6.
Well, paragraph number 6 also, respondent number should be changed.
Oh, yes. It was 6 and 8.
6 and 8.
11.
And para 11, again 6 and 8.
Paragraph 7.
Para 9
7.
and para 7.
Para
7, then 9.
Para 6. Para 6, then para 7, there is any
Respondent number.
Oh, respondent number এটা তাহলে হবে what will be respondent number 6?
8. Respondent number 8, BLLR.
এখানে হচ্ছে 8.
9 ও তাই।
Then
para 9, again respondent number 8 instead of respondent number 6. Then para 11,
6 and 8.
6 and 8.
আচ্ছা, এটা প্যারা 11 এর পরেরটা নেক্সট পেজ।
Then next page, again 6 and 8.
Para 14.
No, para 11.
Oh, আচ্ছা।
নামটা চেঞ্জ হবে।
6 and 8.
And style, name and style would be changed.
Mahalakshmi.
Para 13.
And para 13, 6 and 8.
Oh, 6 and 8.
And 14, again 6 and 8.
একবার দাও তো নাকি মানে আবার ভুল হবে মিস্টার ধর কাইন্ডলি চেক আর এইখান থেকে ওই কোম্পানিটার নাম পেয়ে যাচ্ছে
আমি বলছি প্যারাগ্রাফ নাম্বার 2 রিপোর্ট ডেটটা চেঞ্জ
8/4/2025 টা চেঞ্জ
তারপরে হচ্ছে নেক্সট পেজ
নেই প্যারা 4 এ কিছু নেই
নাম চেঞ্জ
প্যারা ধরে যা
হ্যাঁ প্যারা 2 নাম চেঞ্জ
হ্যাঁ
নাম চেঞ্জ হবে হ্যাঁ
এটা মা ঠিক আছে
প্যারা 6 এ 6 and 8
6 and 8
আচ্ছা প্যারা
আর পার কাউন্টার মিস্টার ব্যানার্জি ঠিক আছে এখানেও মিস্টার ব্যানার্জি
Ten, my lord, I am happy for the petition.
Who's for the state?
My lord, I am for the Bankura Jilla Porishad. My lord, I am praying for not today. Mr. Shoming Ganguly is appearing in this matter. He is left from the court. I am praying for.
The affidavit of service as filed today is taken on record.
Number 11.
Rajni Mukherjee is not in a court. Some due to
Not today.
my lord, kindly after 28th June, he is not in Calcutta. He is in Bangalore due to some
28 June.
28th June. After
28 June.
any
ও
day,
বাবা তাহলে এটা কাজ করো
some medical.
on behalf of the writ petition and accommodation has been state here for the state, Mr. De?
No, my lord.
13?
No, my lord. I have not.
Not today.
14 also.
Ready 14?
Yes, ma'am. Thirteen, 14 and 15 same matter.
Then it will be taken up on a single day. Unnecessarily it will be. 13 who is appearing in 13?
13 I am not.
14 you are 15?
15 and 15, my lord, I am appearing along with Mr. Bandyopadhyay.
In
14 and 15.
who is in 13? No, then it will cannot. What is the matter about?
My lord, only the questions of my lord royalty. My lord, the petitioner is manufactured the brick field from the lifted the soil from
Not today, not today. 13 is 13 will be left out, it will be very difficult. The
16.
My lord, let it be fixed motion, my lord.
fixed motion I don't have. Wait. Already I have.
16.
Lordship, I am for the petition hearing. I am for the. This is the order input hearing is applicable under Rule 51 of the concession rules. So petition may be granted to leave file and appeal before the division authorities. This is the order page 27, my lords.
You prefer withdrawal of the instant writ petition?
Writ petition and liberty may be given to file appeal under section Rule 51 of the concession rules. Just that leave.
At the time of hearing, Petitioner? Not today.
I am for the petition.
State.
Madam, number the state respondent led by Mr. Himadri Shekhar Chakraborty.
Lordship, this is my affidavit of service. There are 7 private respondents. Lordship.
Service has been affected.
Yes, Lordship. There is an encroachment on the state highway which blocked my ingress and egress from my property shop room. Therefore, Lordship, I am praying to initiate the proceedings under section 10.
We'll consider. Respondent number 5.
Respondent number 5, Lordship.
My lord,
Have you submitted the representation?
Yes, Lordship, my representation at page number 34 of my petition.
The respondent number 5 will be the appropriate authority.
yes, my lord. Yes, my lord. My lord, I have received one instruction from the assistant engineer, Kharagpur subdivision. My lord, the assistant engineer already initiated a letter to the BLRO Narayangarh, my lord.
Very good. Understand. Ashut. The affidavit of service has filed.
I'm for the private respondents matter. Lordship, I raised the issue of maintainability of this because by verge of this, Lordship, they have actually sought for the modification of the order passed by the learned coordinate bench. But you kindly come to the last order.
No. He is the reason. I
Yes,
have to
let
hear
him-
him first.
Let him answer.
Let a writ petition was filed in the year of 2024. Let's seeking.
Give me a second, sir. What sort of deed you have sought for?
Let there was a
Writ of mandamus directing extension of time. Anyway, place your case.
that initially a writ petition was filed in the year of 2024. Now, my lord, that writ petition was filed. Now, my lord, it was not moved by the petitioner. Inadvertently, that writ petition was for correction of record, which the writ court cannot entertain. Now, my lord, we after the matter, the writ petition was given to the changeover my advert on record, my lord, we had mentioned it before Justice Rai, and Justice Rai gave us the liberty to approach the LRTT within a specified time period. Now, my lord, we could not file it within that time period, my lord. The order is at page 60 of your lordship's brief.
Yes, sir. Liberty was given, he is seeking an extension of time.
Can it be done by your lordship? I'm raising this question, lordship. It would be the modifying that order. They have not preferred any appeal. That is the difficulty, whole difficulty. And if today
Appeal means?
They have not preferred any appeal against this order, we have not also preferred any appeal against this order. My lord, today if your lordship grants them further time, whether it will tantamount to rewriting this order or rereading, I am asking this question to myself, my lord. Because writ petition was dismissed. A liberty was given. They are still having, they want this direction, they can still file this.
Why
with the
liberty is
application
required?
for limitations.
My lord, because in this order, my lord, there was a specific time period. Now, my lord, we could not.
You want to save time.
No, my lord, I don't want to.
There, it is already
No, the
time barred. Say
It
what?
has become a time barred. In the meantime.
No, in the meantime, I went
Yes.
for the filing, my lord. I have pleaded that also.
No, before
That
the
filing was-
coordinate bench,
Yes,
what is the subject matter of WPA 1247?
same subject matter was for correction of record. Now, my lord,
Correction of record was not considered favorably.
no, we sought because it cannot be, my lord. There is a
correction of record was pending.
correction of record, my lord, we have challenged. There was an error in the record of rights. my
I
lord.
understand.
Now, my lord, the petitioner inadvertently move a writ petition, which cannot be entertained by the writ court because the LRTT has the jurisdiction.
Section 6 is the part.
Yes. Now, my lord, today, my lord, this writ petition was withdrawn.
No, record. So before the coordinate bench WPA 1247, your grievance is for inaction.
Yes, I have annexed that writ petition also. The prayers are also there in this writ petition. If your lordship kindly sees the prayers, my lord, I'll take your lordship through the prayers. That kindly comes to page 32.
Not to disturb the property of the writ petitioner.
This was one of the prayers, my lord.
Don't know how this type of mandamus can be issued.
Lordship, they cannot.
It is practically it is a prayer for a title suit.
Yes. That was the reason, my lord, we had withdrawn by showing the representation which we made to the authority.
Where is the representation?
Which is at page, my lord, 49.
উল্টো পাল্টা করেছে তো।
During the pendency of the
On
title.
the basis of such illegal entry, so you are challenging the record correction of record right.
Each, my lord,
Lordship,
with
this
my respectful submission is
Record of right is an appealable order.
Yes,
it's appealable order. They appeal is time, but if your lordship today, they already made this file this writ petition in order to overcome that. Now, lordship, again,
So you file the appeal.
with the there is a provision for condonation.
May I make one humble
Absolutely.
submission? I am not praying for condoning the delay. What I am praying before your lordship,
No, for the sake of argument, no leave is granted.
No, because
You have
there
to
was-
file the appeal.
Yes, right.
You have to file an application under section 5. Then under misconception, I was pursuing my remedy before a wrong forum.
Tribunal has the power to
My lord, I
condone
will
that.
file an application under section 5. I'll do. Only thing is that kindly comes to the order, my lord, which was passed by Justice Rai, my lord. One, my lord, page 61. However, the petitioner shall be at liberty to apply before the jurisdictional land reforms and tenancy tribunal, restricting his claim only to the extent of correction of records of right and not beyond that. Such an application shall be filed
Sir, I
before
understand. For the sake of argument, this liberty is not given.
My lord,
It
that's
will
my
be, will
filing
be
has been-
debarred.
My lord, my filing has been refused. That's my specific case.
No, how can it be? Then you should make the registrar of that
Such an
tribunal
application
the
shall be filed before the within a period.
Within a 4 weeks from date. Now, my lord, that period has expired, my lord.
And that, if that is, they should have filed the application for modification of this order before the same court.
So if it is even if it is not we filed within 4 weeks, what happened? They will not accept.
My lord, the person who has, the advocate who has gone for filing, my lord, that is my specific case in the averments, my lord, the filing has been refused.
Then lordship, this has to be filed against the registry.
This application only being made for
It cannot.
It cannot be.
It
Lord,
cannot.
only, my lord, extends me the time for filing. Your lordship needs not enter into the I'll file an application for condonation of delay.
They have to file a BC case before the concerned BLRO.
Where is the pleading to their effect?
Nothing.
Lord, my pleading starts from paragraph number 5.
No, where is the pleading, specific pleading to that effect? That the registry of the tribunal has refused to accept.
page 10, my lord, ground 3, I find. Grounds number 3.
কোথায় যাবো? Sorry. Para 8, page 9.
Where is the representation to the effect, lordship asked them?
Page 9, paragraph 8.
And representation is dated? Huh? No, is it illustrated?
Page 49.
49? This was on, na, এই যে registry নিচ্ছে না? Application করেছো? Application করোনি? You should make the application before the registry on this.
Take down.
my lord. Sorry.
এটা কি হলো দেখো খুঁজে পাচ্ছি না।